This is the first in a series of short videos which myself and my colleagues at the Liverpool Law School are going to post online in an effort to help explain some of the key issues which are going to surround the UK's withdrawal from the European Union. Our intention isn't really to provide a running commentary on political developments. What we really want to do is highlight some of the key challenges and questions which will arise as the process unfolds, and offer some reflections, particularly on the legal dimension to some of these questions and challenges, so as to help better inform the interested public, stakeholders, policymakers. In this video, I'm going to say a little about the government's ideas for ensuring continuity and certainty in the UK legal system during the process of leaving the EU. Because withdrawal really presents us with two quite important tasks. The first task is to prepare the legal system for withdrawal without creating either damaging legal vacuums or undesirable legal certainty. The aim being to preserve continuity and predictability for public authorities, for businesses, for individuals. And the second task is to make more substantive decisions about which aspects of our European legal heritage that we want to keep as part of our legal system into the longer term, the parts that we want to have removed altogether, the parts that we want to reform, and if so, how we want to reform them. Now, taken together, those twin tasks are very large, they're very complicated, and they also involve really fundamental policy choices that will touch upon every aspect of national life. Because leaving the EU is really as much about fundamentally changing our own legal and political system as it is about actually leaving the EU. Now, the question is, how do we go about these twin tasks? And really one option would have been to try and do both together, to try and undertake a fairly comprehensive review of the UK legal system and make systematic decisions, sort of directive by directive, regulation by regulation, about what we want to keep, what we want to axe, what we want to reform, in preparation for withdrawal. Now, this never felt like a particularly credible option because the task would have been so enormous and so complicated that it just didn't seem feasible within the timescales laid down for withdrawal in the treaties. And so instead, the government has indicated that it would prefer a more simple solution. And that solution is really to try and achieve the task of preserving legal certainty and continuity by incorporating existing EU rules into UK law at the point of withdrawal through the rather ironically named Great Repeal Bill. But then leave the task of making substantive decisions about which parts of EU law we really want to keep, we really want to axe, we really want to amend for future politicians in government and parliament over the years and indeed decades to come. Now, to be a little bit more precise about the nature of this strategy, we should remember, of course, that a lot of EU law is already incorporated into the UK legal system, both by Act of Parliament and by statutory instrument. So a lot of the focus of the government's proposal will relate to those parts of EU law, mostly regulations, which take effect within the UK without any existing specific implementation measure. The idea being that we would give these EU regulations and other similar provisions a new domestic legal basis that would preserve their legal force and their legal effects even after withdrawal has become effective. Now, this is presented as a simpler solution, and indeed it is obviously much simpler than the comprehensive review. We deal with the form, we worry about the content later on. But it's not necessarily as simple as it sounds either, because there will still be a very large and very technically complex task, and it will still involve quite a lot of important and potentially sensitive policy decisions. And I'll just give a few examples. First of all, we have to actually make a decision about which EU rules will remain relevant to the UK after withdrawal. And we're not just talking here about rules on olive oil production or feta cheese. What we're talking about really are all of those EU rules which are predicated upon membership of cross-border networks, cross-border frameworks, all of those situations where national decision makers work together with each other so as to find common solutions to cross-border problems. And the simple fact is that in many of those situations, the EU rules won't necessarily be very relevant anymore to a country which is not part of those networks, which is not part of those frameworks. So the question is, what do we do about them, and what can we do about them? Another example, what about all of those EU measures which involve EU bodies or agencies having decision-making powers which have legal effects within the national system? We obviously don't want to have a situation where external bodies are still recognised as having decision-making power within the UK. So who do we give those powers to in fields like anti-dumping or freezing terrorist assets or medicines regulation? Who should exercise those powers? Should they be politically exercised or should they be given to more autonomous and independent agencies? And what happens if the relevant EU rules change? What happens if the EU subsequently amends or reforms its own legislation? Do we simply keep to the old rules even though nobody really thinks they're fit for purpose anymore? Or do we somehow automatically try and update our incorporated EU rules to follow the EU example? And of course there will still be plenty of fields where it's not enough simply to try and incorporate EU rules into the national legal system, where it will be necessary for Parliament to try and redesign a whole new legislative framework, and that's most obvious in a sector like agriculture, where we'll be faced with the challenge of simply designing new sets of regulations to deal with our own economy, our own business. So even this apparently simple solution will require a fairly comprehensive review, lots of technical questions, but also some difficult policy questions as well. And so although the Prime Minister indicated that any changes in the law will be subject to full scrutiny, to proper parliamentary debate, it's still difficult to see how this can realistically be done without quite an extensive delegation of power by Parliament to the executive. And we don't yet know what the government's proposed legislation will look like. We don't yet know how much power the government will claim for itself to make these decisions, even in the process of withdrawal, about what to keep, what to axe, what to change, how to change it. And especially, we don't know whether the government envisages that these powers will only be in preparation for withdrawal, or whether they might even extend after withdrawal so that they can be exercised into the future. Now, just as importantly, if not even more importantly, where does that leave us with the future task, the actual substantive decisions about which parts of our European legal heritage we want to keep for the future, we want to axe, we want to change, and if so, how? Now, obviously, like so much else in this situation, there's a lot of uncertainty, a lot of speculation, but there are some basic legal constitutional principles that we can rely on to help make a few key observations. And I'll just highlight three key points. And the first point is that what withdrawal will do is see a sort of repoliticisation of various areas of policy making which we've grown used to being dealt with at the European level, often in a way which deliberately seeks to insulate those policy choices from the sort of messy business of everyday politics. The member states, through their EU membership, have quite consciously made the decision that certain policy fields should be done on a more objective basis, a more autonomous basis, shouldn't be subject to constant right-wing, left-wing disputation. Now that's true in fields like competition policy and state aid control. It's been true, for example, in the allocation of EU research funding or structural funding. It also underpins a lot of the EU's regulatory approach to things like climate change or environmental protection. Now, leaving the EU will mean that those types of policy choices will become fully and entirely subject again to the full processes of national political contestation. And we'll have to decide, for example, whether we're content to let the elected governments do as they please in those fields, or whether we would rather try and replicate some of the more autonomous decision-making processes and institutions that used to exist for us at the EU level. Now, it's not for me to say whether that's a good thing or a bad thing, it's just to say that this is what will be an inevitable part of leaving the EU for our legal system. Second point, the legal framework for this repoliticisation will change most strikingly in those areas where EU law currently provides a minimum safety net of regulatory standards below which the member states are not meant to go. Remember that the single market is based on the idea of free but fair competition, the idea that member states shouldn't be able to compete with each other on the basis of axing certain basic standards of social and welfare protection for workers, for consumers, for the environment, and so on. And so EU law sets minimum standards of protection in those and other fields to ensure that competition and market forces can't undermine basic social and welfare standards. Again, leaving the EU means that those safety nets will go. And it will be open to future governments to decide that they do want to deregulate them if they so wish. Now, it's fine for the Prime Minister to say, as she said in her speech at the Conservative Party conference, that workers' rights will be protected while she is Prime Minister. But of course, that's no guarantee for the future for any longer than that. Now, again, it's not for me to say whether this is a good thing or a bad thing. It is just to say that it becomes entirely possible, and that will be true in a way which it simply wasn't while we were members of the EU. The final point, which is worth talking about a little, is that these questions about the future evolution of our own legal system are inseparable from the issue of our future external relations, both with the rest of the EU, but also the rest of the world. For example, depending on the deal that we do eventually reach with the EU about future cooperation in trade or the environment or security, we might well simply have to keep many of these existing rules to adapt any new rules that the EU adopts for itself, just as if we were still members. It's just that we won't have any of the existing, say, or influence that we have as a leading member of the EU. Probably more importantly, the UK is faced with the challenge of developing our own trade policy. For the first time in really quite a long time, we have to develop our own idea of what we want to achieve in the field of international trade. And trade policy, although it's very technical, it's very complicated, is also very politically motivated, very politically charged, and very controversial, because it involves making fundamental choices about which parts of your own economy, which parts of your own society that you're prepared to bargain away in order to gain greater access to foreign markets. All trade policies involve some sort of balance between winners and losers. And the balance that's struck in the UK in its external economic relations will have tangible and potentially significant policy implications for our own legal system as well. It'll influence and constrain the choices that we make about economic regulation, workers' rights, environmental protection, and so on. So UK withdrawal isn't just about finding a new relationship with the EU, it's also about opening our own internal legal and political systems to really far-reaching processes of change and reform. And much of that change will inevitably be deeply controversial within our own society, within our own political system, but much of it will also be driven, or at least influenced, by our new place in the world and the new balances of power that emerge between us on the one hand and the international partners on the other.